I next turn to the aspect of physical safety of journalists, a parameter highlighted in RSF's report. On 3rd May 2024, the World Press Freedom Day, the India Freedom of Expression Initiative, an alliance of press freedom NGOs, released the India Press Freedom Annual Report. The report pointed out that in 2023 alone, 5 journalists were killed. Of the 226 others targeted, 148 journalists were targeted by state actors and 78 by non-state actors that included politicians and criminals. Delhi reported the highest number targeted by state agencies, 51. 12 of these were women. The forms of targeting were arrests, detentions, registration of FIRs, being summoned for questioning, impounding of passports, raiding of dwelling places. 26 were physically attacked, threatened, or harassed by the police. Almost half of the 28 journalists killed in India since 2014 have been those covering environmental issues. They had invited the ire of the sand mining mafia and the criminal networks. 2024 has been no better. On 10th February 2024, Jyotiranjan Mahapatra, a reporter with the Bada Khabar TV in Orissa, was brutally attacked for his reporting, resulting in severe injuries to his head and hands. One day earlier, Nikhil Wagle's car was attacked by the ruling party workers while he was traveling in Pune to speak at a program. He had been critical of the Prime Minister and the former Deputy PM Advani after the latter was awarded the Bharat Ratna. Vinay Pandey, a journalist based in Nagpur, received on 31st May 2024 a beheading threat for reporting on the Gaza conflict. On 23rd May, Ankur Jaiswal was attacked by a politician and his cronies for publishing material that exposed their activities. Stopping journalists from traveling abroad at the last minute while they are set to board a plane has also been happening with regular frequency. While Rana Ayub could get the Delhi High Court to come to her rescue when she was set to travel to Europe to deliver talks on violence against women journalists, Sana Irshad Mattu, a Kashmiri photojournalist who won a Pulitzer Prize, was in October 2022 stopped at the Delhi airport despite having a valid US visa and prevented from receiving the prestigious award in New York. No reasons were given. Fahad Shah, Sajad Gul, Asif Sultan, Majid Haidari are some of the other Kashmiri journalists who have faced arrests under draconian criminal law provisions, including the Public Safety Act, and have been released after long periods of incarceration, sometimes in jails far away from Jammu and Kashmir. They were simply doing what any other journalist there would have been expected to do, reporting on the current situation. In Manipur too, senior journalists have been arrested. But then journalists elsewhere in the country who have been and are fearless in their reporting of events have been subject to arrests and secret surveillance by the state apparatus, as the Pegasus episode revealed. It is getting even more difficult to ignore the RSF report on India press freedom. The legal framework under which the media operates in this country includes the formal statutory body, the Press Council of India, headed by a former judge of the Supreme Court of India. The Press Council entertains complaints from the press against interference with its freedom by an authority, or complaints against the press by individuals for violation of the Code of Ethics. The Press Council exerts high moral authority, but is sadly, by and large, an ineffective oversight body. When its website prominently displays the PM's Pariksha Pe Charcha program, urging viewers to join the event and get unique tips from him, it raises eyebrows. The other body, which is a self-regulatory one for the electronic media, is the News Broadcasters and Digital Association, which has drawn up a code of ethics and broadcasting standards expected to be binding on its members, which are 27 news broadcasters, comprising 125 news and current affairs channels. Although it does adjudicate complaints and pass orders, these are often not complied with, making self-regulation a meaningless term. I now develop 3 themes. When I survey the terrain of courts and the media, 3 broad themes emerge. The first is that in order to be truly free and independent, the media in a democratic polity needs an independent judiciary. The second is, for an independent judiciary to remain effective in a democracy, it requires a free media. The third theme is that frequent use by the courts of the contempt jurisdiction has had a chilling effect on the freedom of the press. The first amendment to the Constitution sought to add restrictions on the freedom of speech under Article 19(1)(a) of the Constitution, which by then was recognized as including the freedom of the press. The amendment was triggered by two decisions handed down by the Supreme Court in 1950, the very first year of its functioning. The first in Ramesh Thapar lifted the ban imposed by the Madras government on Crossroads, a newspaper espousing communist causes and which was critical of Nehru's government. The ban cited danger to public order. The second decision in Brijbhushan Sharma struck down an order by the police commissioner here in Delhi under the East Punjab Public Safety Act, whereby the organizer, the mouthpiece of the RSS, would have to submit its issue in advance for a pre-publication censorship. Here too, public order was cited as the reason. With the Supreme Court having struck down both these orders, the consequential amendment to Article 19(2) in 1951 expressly introduced public order as an additional restriction on free speech. The Supreme Court has been consistent in upholding the freedom of the press in matters challenging government measures to control the price of newspapers, the levy of excessive customs duties on newsprint, or even issuing ejectment orders alleging violation of building bylaws or lease conditions. You will remember that the Indian Express building in Bahadur Shah Zafar Magh was the subject matter of a very famous case in 1985 in the Supreme Court, and the court struck down those ejectment orders. The Supreme Court clarified in the Cricket Association of Bengal case that the right to communicate included the right to communicate through any media that is available, whether print or electronic or audiovisual. I now come to a very important judgment which somehow has not been commented enough upon. In 2023, the Supreme Court set aside a Ministry of Information and Broadcasting order dated 31st January 2022, revoking the permission granted to Madhyam Broadcasting to uplink and downlink a news and current affairs channel, TV channel called Media One. The reason for revoking the permission was that the Intelligence Bureau had not given security clearance. When asked about this, the Solicitor General tendered to the Supreme Court the reasons in a sealed cover. The Supreme Court said it was not going to entertain such grounds for revoking a permission of a media channel in a sealed cover. It opened the sealed cover and in fact discussed the contents of the sealed cover in its judgment. One of the grounds on which the security clearance was denied was that Madhyam had been taking an anti-establishment stance. References were made in that report of the IB to Madhyam's reports on the UAPA, on the Armed Forces Special Powers Act, on development projects of the government, encounter killings, Citizenship Amendment Act, NRC, and the Indian judiciary's alleged double standards in terrorism cases. The second major ground for denying security clearance was that members or sympathizers of the Jamaat-e-Islami Hind had invested shares in Madhyam. Both these grounds were negatived by the Supreme Court, which reiterated that an independent press was vital for the robust functioning of a democratic republic. It said, and I quote, "The press has a duty to speak truth to power and present citizens with hard facts, enabling them to make choices that propel democracy in the right direction. Also, the critical views of Media One on the policies of the government could not be termed anti-establishment." This is what the Supreme Court said. The use of such a terminology in itself represented an expectation that the press must support the establishment. The denial of security clearance was viewed as producing a chilling effect on free speech and in particular on press freedom. The Supreme Court emphasized criticism of government policy can by no stretch of imagination be brought within the fold of any of the grounds stipulated under Article 19(2). Separately, the Supreme Court found that there was no material to conclude that the investment by the Jamaat-e-Islami Hind sympathizers would affect India's security, or even to prove that Madhyam's shareholders were such sympathizers. The ministry was asked to renew the permission for uplinking and downloading of the Media One channel. And yet, when individual journalists who have been subjected to the criminal law processes have approached the Supreme Court, its response has been inconsistent. Some have received protection from arrest and bail in good time. Some have had to wait for long. Some have not been given any relief at all. A satirical comment in this context by a stand up comic that some litigants were more privileged than others invited contempt of court proceedings being sanctioned against him by the then Attorney General. What seemed to have precipitated the move was the gentleman retweeting a cartoon that suggested executive dominance over the judiciary.